The EPA appears to be taking an all or nothing approach, and the durability of these actions will largely be determined by the courts. Even in instances where EPA is reducing the stringency of standards, a new administration can revise those standards in the future to make them more stringent. And this puts industry in a tough spot, particularly when it comes to long-term planning.
Welcome back to the Environmental Evolutions Podcast. I'm your host, Linn Bumpers. Today, we're finishing up a two-part series where we are gathering insights on EPA priorities and actions during the second Trump administration from former EPA attorneys.
Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney-client relationship. This communication may constitute attorney advertising.
This second episode focuses on EPA's new regulatory strategy and priorities. I'm joined today by Mark Talty, a former EPA attorney who is now in Baker Botts' Environmental Safety and Incident Response Group. Mark is a special counsel in our Washington, D.C. office who has spent nearly a decade working in the Office of General Counsel at EPA. During his time at EPA, Mark counseled program staff and senior leadership in the development of regulations and policies with agency-wide scope and significant external impact across each of the agency's substantive statutes. He also worked closely with the Department of Justice, including the Office of the Solicitor General, in challenges to EPA actions and in high-profile litigation with EPA equities. Now, drawing upon his invaluable government experience, Mark advises clients facing complex environmental challenges and assists them at every step of the regulatory process through regulatory advocacy, compliance counseling, and litigation. He assists companies and national trade associations across the manufacturing, chemical processing, landfills, and energy sectors, including extensive work on renewable fuels. Mark, thank you for joining the podcast today. Let's start with the big picture. What do you see at the top of EPA's agenda right now when it comes to regulatory development?
I think it's fair to say that this administration is laser focused on reducing and, where possible, eliminating regulatory burden. I think this is reflected first in the slew of day one executive orders, including the Unleashing American Energy executive order that directed agencies to identify existing unduly burdensome regulations and policies impacting the energy sector and develop plans to revise and rescind those regulations and policies that the agencies identified. I think in many ways, EPA is leading the charge when it comes to implementing this overall deregulatory agenda by the Trump administration. And as we all know, in March of last year, EPA identified 31 separate actions for reconsideration, which I think serves as the agency's current roadmap for significant regulatory actions. But I think in terms of the top of the agenda, it's hard to ignore EPA's focus on dismantling the climate-related regulations developed during the Obama and Biden administrations, chief among them EPA's recent rescission of the 2009 Endangerment Finding and its forthcoming rules on the Section 111 power plant rule, and also the potential rescission of the greenhouse gas reporting program.
And how does that compare to Trump's first term? Are you seeing a different playbook this time around?
Yeah, I think it's fair to say that this Trump EPA came in with a clear set of priorities and an agenda that it wanted to achieve. I think this goes back to being able to issue that list of 31 actions in March, only 3 months from the inauguration of President Trump. The agencies moved quickly to issue proposals on significant actions in the spring and summer of last year. And now we're beginning to go final on several significant rulemakings. And I think a great example of this EPA being ready to hit the ground running almost immediately is the EPA's use of the little-known presidential exemption authority for niche apps under Section 112I4 of the Clean Air Act, which had never been used by any administration in history. And just the attention to detail and being ready to exercise something like that within only a few months of taking office kind of shows the planning and preparation that went into this EPA being ready to execute on its deregulatory agenda. And I would just say that was really opposite of what occurred during the first Trump administration, when EPA came in and fumbled around a little bit and was initially focused on stopping the implementation of Obama-era policies, and in doing so got bogged down in litigation over staying those actions and really set them back and further delayed their ability to reconsider the underlying policies, hampered their overall ability to implement the deregulatory agenda under the first Trump administration. The second point I think that's really different is that the current EPA is much more aggressive in its deregulatory efforts, both from a legal and a policy perspective. And I think that shift is a direct reflection of some of the significant changes that occurred in the 8 years between President Trump's first inauguration and his second inauguration. Most notable of those changes is the significant remaking of the Supreme Court, which now holds a 6-3 conservative majority. And that newly constituted court has issued several landmark administrative law decisions within that time frame. These include some of the obvious ones like West Virginia versus EPA, bringing back to the forefront or reconstituting the major questions doctrine. There's Loper Bright, which overturned Chevron deference. And there are even other cases like the Corner Post decision, which was issued concurrently with the Loper Bright decision that upended long-held views on the APA statute of limitations, and even a decision like the Jarchese decision, which upended potential civil enforcement authority for federal agencies. These decisions taken together, I think, can be viewed as the Supreme Court signaling its efforts to cut back more broadly on the authority of federal agencies. And when this administration came in, I think it's fair to say that all of these factors emboldened them to be more aggressive in its deregulatory efforts. And I think it's no surprise that you find citations to these cases, in particular West Virginia and Loper Bright, throughout EPA's recent regulatory actions.
I definitely agree. You mentioned the speed at which EPA is moving. Can you walk us through what's driving that speed and whether it raises any concerns to you about how stable or predictable environmental rules will be going forward?
I think EPA is making a very strategic decision here, particularly in some of these early significant rulemaking actions, to rely heavily on new legal interpretations to justify its actions, in particular on the cases that we just discussed. I think EPA is taking what amounts to a calculated risk that by grounding its action in these legal interpretations and arguing that the statute, the best reading of the statute under Loper Bright in particular, compels the final result that the agency is reaching, or in the case of the proposals, that is proposed to reach. It can avoid having to grapple with the sometimes significant scientific and technical findings that underpinned the original actions that are being reconsidered, which can dramatically slow down the rulemaking process. This is, I think, consistent with the approach that EPA adopted in its recently issued final rule rescinding the endangerment finding, in which it dropped its record-based rationale and instead relied solely on its reinterpretation of Section 202 of the Clean Air Act.
That's really interesting. And for any listeners who haven't already checked out our separate episode on the endangerment finding, we recorded it shortly before this and it should be available. But separately, for companies trying to navigate all of this, what should they be doing now with their compliance programs, especially if they're thinking long term?
I think EPA appears to be taking an all or nothing approach to some of these significant actions, and the durability of these actions will largely be determined by the courts. For instance, with the endangerment finding, which we just talked about, if EPA ultimately wins in the court, the agency would be prevented from regulating greenhouse gas emissions from mobile sources going forward. That obviously would create a certainty on the part of mobile sources. But if they lose, the Biden-era emission standards will spring back into place. Even in instances where EPA is reducing the stringency of standards as opposed to disclaiming authority like it does in the endangerment finding, a new administration can again revise those standards in the future to make them more stringent. And this obviously puts industry in a tough spot, particularly when it comes to long-term planning. Until these significant issues are resolved in the court, companies may want to make only minor adjustments in the short term, but stay the course in terms of long-term planning. I think this is especially true in certain states that may attempt to fill the regulatory gaps that are being left in the wake of this EPA's deregulatory agenda.
So thinking about companies that want to be heard by EPA, do you have any advice on the best way to get their priorities on the agency's radar?
This is a great point. There are a lot of industries and sectors that are lining up at the door of EPA headquarters with a long list of items that they want this administration to address, which don't always mesh with this administration's priorities, which are very focused on reducing the burdens in the energy and manufacturing sectors. Couple that with the very real resource constraints at EPA, losing nearly a quarter of its staff since President Trump took office. It can be very difficult to get traction with the agency, but there are some strategies that can help you if you find yourself on the outside looking in. One, you can try to be, I think it helps to be as surgical as possible when making an ask of the agency. If you want a program overhauled and you're not on the list of agency priorities, it likely isn't happening. So, where possible, you want to identify a specific set of changes that would be most impactful to you and your industry, and then bring those to the agency. A second point is that you may want to start working with career leadership, because getting their buy-in on some of these more narrow issues can ultimately help you before going to political leadership, because oftentimes the political leadership is just going to turn back and ask the career leadership its thoughts and its feasibility of achieving the ask that you're making of the agency. The third is petitions for rulemaking. Now, these can often languish at the agency, but if you're strategic about how you go about it and you create narrow, focused petitions that does a lot of the work for the agency, you may find yourself having better success in getting the agency to move on it. Fourth, you can explore whether your issue can be addressed by something other than a regulatory fix. You might want to explore whether or not guidance issued by the agency could effectively address your concern, or maybe even a new interpretation of the existing regulatory text. These efforts can often be a lighter lift on the part of the agency and would take less time than the normal rulemaking process. Lastly, there are legal mechanisms like mandatory duty and unreasonable delay suits that can be utilized to force EPA actions, but these are relatively drastic measures, and you want to consider closely all of the consequences and the pros and cons of using such a maneuver.
That is a really helpful checklist for companies to have in their pockets to address regulatory concerns. If you're looking ahead, what is on your radar? Are there regulatory reversals or litigation trends or policy shifts that industry should be watching closely?
I think I'll be watching for a couple of things. I think first, I'm going to be looking closely at the early litigation strategy and these legal challenges to this initial wave of deregulatory actions by EPA. In particular, the legal challenges to the endangerment finding rescission. I'm looking at things like, will the environmental group seek a stay? I think so. Will the DC Circuit grant that stay? If so, would DOJ seek emergency relief from the Supreme Court to vacate the stay? And also, would DOJ, in an effort to expedite the litigation and move it along to an ultimate decision by the Supreme Court, ask the DC Circuit to hear the challenge en banc rather than going through the normal three-judge panel? This was done actually for the Obama era Clean Power Plan. The second thing that I'm looking toward, and I think companies should be on the lookout for, to what extent do states attempt to fill the voids that are left by EPA's deregulatory efforts? And in a counter move, what does EPA and DOJ do to respond to such efforts? We've already seen DOJ take action in the context of these kind of climate superfund laws in seeking relief from federal courts in efforts to halt those state efforts. And so I would anticipate that DOJ would continue those aggressive efforts in future state actions, but that will be an important marker as we move forward through the rest of the Trump administration.
Agreed. And it can be really difficult to wrap your arms around the patchwork of different state laws. We do a lot of state tracking for clients so that they can see what is happening on every state level when EPA is absent. But I really appreciate all of these excellent inputs, and it sounds like there are a ton of new, interesting regulatory hurdles and developments that we've seen in this first year of this administration. Thank you so much, Mark, for sharing your expertise in this field and for joining me today.
Thank you for having me.
Thank you for listening to this Baker Botts podcast. Baker Botts has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on Baker Botts practices, please visit us at bakerbotts.com. This presentation is provided by Baker Botts, LLP, for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.